Yes, well, thank you, Richard. I always say I had 3 clerkships, and my first clerkship started while I was still in law school. So Richard has been one of my biggest mentors throughout my career. It's hard to believe it's been 20 years since I graduated. But without Richard's mentorship, there's no way my career would be where I am today. And I do remember the meeting. I probably was shaking. I'll probably shake today as well. So there you go. Not a lot of stuff changes. I would say about the Amex case, I tend to think that this is why he asked me to come deliver this lecture today, because when we talked about the case later, so Amex was about American Express's refusals to allow merchants to tell consumers about the price or the cost of Amex cards. And so I said that there was just a basic economic problem because consumers who are making the purchasers' decisions do not know the cost that they are imposing on the merchants because the merchants can't tell them. And so the price mechanism was really important in this case. And so I thought it was a perfect example of citing Hayek's. You know, he's famous for his economic work and the importance of price and how price will always beat socialism. So I think it was at Chicago a couple of years after this case was over, I tell Richard, well, you know, I did cite Hayek in that case, and he had a one-word response, wrongly. So a couple of things in response to that. Number one, caveat emptor. So hopefully the things I say today will not be equally wrongly as the citation that I had back then. And then also I tend to think that that's why he invited me, because he wanted me to, I'm back in law school now. He wanted to re-educate me on the proper Hayek. So I did end up reading a couple more of his books that I hadn't read before. Law, Legislation, and Liberty I had not read. I reread the Constitution of Liberty as well. I do find Hayek's views quite interesting, as I will get into. I don't want the lecture to go too long, however, so I should get started. Okay. So what is the level of generality problem? Let's try to make it less abstract. Most constitutional provisions that come before the courts are written in general and seemingly categorical terms. So, for instance, the First Amendment tells Congress that it shall make no law prohibiting the free exercise of religion or abridging the freedom of speech, and the Confrontation Clause gives an accused the right to be confronted with the witnesses against him. Should we interpret these words just like we would interpret the text of a recently passed law by asking how an ordinary person would understand them? The answer is yes in part and no in part. Yes, at a high enough level of generality, the text can narrow the range of debate. The word speech shows that the free speech clause applies to forms of expression, not pure conduct. And the word witnesses shows that the confrontation clause applies to people, not physical evidence. But most interesting questions fall within a plausible reading of the text. So one cannot entirely understand the text of most provisions of the Constitution just by opening up a dictionary. Consider 2 examples. If a group requires human sacrifice as part of its exercise of religion, does the Free Exercise Clause prohibit the government from prosecuting the group for murder? As Justice Alito has noted, nobody has ever seriously argued for that expansive view, but the rejection of the view has to come from something other than dictionary definitions of the words exercise and religion in 1791. Likewise, if a witness lies during a trial, does the Free Speech Clause prohibit the government from prosecuting the witness for perjury? The Supreme Court has long upheld perjury laws. Yet again, the conclusion will not follow merely from examining the dictionary definitions of freedom and speech. The level of generality problem arises once we recognize that the text cannot resolve many specific questions. We instead must look elsewhere. But where should we look? So that's kind of what I want to talk about today. And I would like to discuss primarily one question, and I might have time for another on the back end. But the one question is, first and primarily, what should a court have as its ends when deciding on the level at which to read a right? Should the court ask a normative policy question or an objective historical one? And so let me explain why this question really matters today more than ever. So on this history versus policy question, the Supreme Court really sits at a crossroads. Each term, it issues opinions that contradict each other over the proper ends of interpretation. In some cases, the court undertakes a normative inquiry that picks the level of generality at which to read the Constitution by asking a policy question about what will best help society, upholding the law or protecting the right. Under this approach, for example, under my prior perjury example, the free speech clause permits perjury laws because the government serves important goals when it stops people from lying under oath at trial. But in other cases, the court undertakes an objective inquiry that picks the level of generality based on our traditions. So under this competing approach, the perjury laws would be upheld because they existed at the time of the founding and have continued to the present time, without regard to the merits of what they are designed to protect. So where did these approaches come from? How common are they? I just want to briefly talk about each, and then I'll turn to what I think would be Hayek's views on what is the proper approach. So start with the policy approach. Again, it interprets a text by asking if the government has a good enough reason to take the action that it did. And I would put in this approach, as Justice Kavanaugh recently explained in the Rahimi decision, all the levels of strict scrutiny, rational basis review, intermediate scrutiny, anything that ties the constitutionality of a law to an assessment on the law's validity. So strict scrutiny might require, a compelling interest, whereas rational basis review might require only a legitimate one. But each of them both tie the validity of whether the law serves a good enough purpose, with the conclusion about what qualifies as a good enough purpose left to the judges. So this approach, as many scholars have noted, this approach has really dominated Supreme Court jurisprudence, at least since the 1950s. It pervades the First Amendment and many other amendments. To give two examples under the First Amendment, a law that is content-based can survive if the government serves a compelling interest in the least restrictive way. A law that is not content-based can survive if the government serves an important interest in a narrowly tailored way. Both of these tests don't ask about history. They just ask about whether the legislature has served a good enough purpose. You could cite many other provisions in the due process context. Matthews v. Eldridge balancing ask whether the process that was given is enough based on the right or the liberty interest that was being taken away. Again, it's the judge's assessment on good policy. It also invades structural provisions. State laws are upheld or not upheld under the Commerce Clause under a balancing test that asks whether they clearly exceed, whether the burdens on interstate commerce clearly exceed the state law benefits. So this policy approach is everywhere today. And I've always been curious about where it came from. Justice Kavanaugh in his Rahimi concurrence suggests that it arose by accident in the First Amendment context, in the free speech context. I think that's true if you just look at First Amendment cases. The first explicit balancing opinion dates to 1939. It's called Schneider versus New Jersey. And in this case, the court just adopted balancing. It recognized that the categorical language of the First Amendment conflicted with the court's view that the First Amendment did not adopt an absolute right. And the court was struggling with, well, how do we reconcile these two? What do we determine falls within the First Amendment and what do we determine falls outside of it? And the court just, in a key paragraph really, the court said, the difficult task of measuring the substantiality of the reasons advanced in support of the law against its intrusion on speech is the relevant test. In that case, it was about littering. It was about a ban on handbills, on handing out handbills on the public streets. And the court just said that that wasn't a good enough reason to restrict speech and handbills. So it seemingly arose by accident if you look at that context. But I think it would be a mistake to suggest that it arose accidentally. In fact, I think it was just the legal realist movement of the 1930s that really developed this into what it is today. And so the realism has been described as the most important indigenous jurisprudential movement in the United States during the 20th century. And although different strands of realism existed, there were the two shared premises that I think led to really policy-rooted judging. The first of these premises is what Justice Holmes would describe as the fallacy of the logical form. The realists disputed the formalist claim that they ridiculed as mechanical jurisprudence, that judges decided cases exclusively by applying general principles to specific facts. They said instead that there was some other interest being used as the decision-making factor. Justice Holmes expressed this view in The Path of the Law, his groundbreaking work. There he said judges dress up their decisions in the processes of analogy, discrimination, and deduction to make it seem like the decisions followed inexorably from general principles, but he added, and I quote, "Behind the logical form lies a judgment as to the relative worth and importance of competing legislative grounds. Often an inarticulate and unconscious judgment, it is true, and yet the very root and nerve of the whole proceeding." So the fallacy of the logical form, the idea that general legal sources decided concrete cases, is the first of the two legal realist attacks on traditional judging. The second is what the realists disputed what Justice Cardozo described as the old Blackstonian theory that judges found and did not make law. Under this older theory held by Cook and Hale and Blackstone, judges did not legislate even in common law cases. The realists, by contrast, started equating judges and their functions with the functions of legislators. This view grew out of their legal positivism. So they suggested that law could not exist without some definite authority behind it, and agreed with Thomas Hobbes that it was not wisdom, but authority that makes a law. So Justice Holmes ridiculed that there could be a common body of legal principles that developed across jurisdictions as the brooding omnipresence in the sky. And because judges had the sovereign voice when they actually decided cases, the realists suggested that the judges actually made law in this capacity. Justice Cardozo expressly said, the judges legislate narrowly between the gaps in the law. So these positions, that traditional sources don't decide cases, and that judges act like legislators, led them to start openly suggesting that they should adopt a legislative role by making judgments on matters of social and economic policy. It was fascinating. So Justice Cardozo advocated for this in The Nature of the Judicial Process. He had a chapter of the nature of the judicial process entitled History, Tradition, and Sociology. So if you're an originalist today, one of these things does not belong with the other two. But of these, he said that sociology was the greatest. So he believed, and I quote, "When judges are called upon to say how far existing rules are to be extended or restricted, they must let the welfare of the society fix the path." And so you can find similar statements from many realists or folks associated with the realist movement around the time. Roscoe Pound called for judges to engage in a process of social engineering designed to satisfy a maximum of human wants with a minimum of sacrifice of other ones. So these realist theories that judges should really be thinking about policy questions really influenced the law in multiple ways. They fundamentally changed the common law. So with the common law today, all of us are learned in 1L class that judges make the common law. It also influenced the change from Swift v. Tyson, where at one time the federal courts would apply their own versions of the common law in diversity cases. To Erie in 1938, Justice Brandeis flipped and said, no, the common law actually comes from authority. It's the authority of the state. So we have to be bound by the state common law decisions of the state courts. And then it eventually laid the groundwork in the common law for Judge Posner and the idea of the welfare maximizing judge, looking at consequences and setting legal rules. So that's in the common law domain. Obviously, this is about constitutional interpretation, but Justice Cardozo expressly said that there was no branch of law that the social welfare method could not help, and the Cardozo thus called for judges to consider social welfare even in constitutional interpretation. It led to two changes around the time. The first is what we know of the living constitutionalism today. Justice Cardozo suggested that the content of constitutional immunities is not constant, but varies from age to age. And then the realists also thought that the judges should solve the level of generality problem, like how do you determine whether some government law falls within a constitutional provision by weighting the competing interests at stake. So engage in express policy about what should be better. And I don't think any case better fits this idea of judging than Home Building and Loan Association versus Blaisdell from 1934. There, a Minnesota law allowed homeowners who had defaulted on their loans to extend the period in which they could redeem their foreclosed properties. The court upheld this law against a challenge under the Contracts Clause, which bars states from impairing the obligation of contracts. And the court's logic showed both of these ideas that I was talking about, how the legal realist changed the nature of constitutional interpretation. For one, the Contracts Clause was specifically designed to prevent this type of debtor relief legislation. There was a lot of the legislation pre-existing the Constitution, and that's why it was put in. But the court said in response to this kind of traditional, with the reason for the Contracts Clause, it said, if by the statement that what the Constitution meant at the time of its adoption, it means today, it is intended to say that the great clauses of the Constitution must be confined to the interpretation which the framers, with the conditions and outlook of their time, would have placed upon them, the statement carries its own refutation. So it didn't even think it needed to justify the idea that there could be a fixed Constitution. The statement itself carries its own refutation, apparently. And next, the court explained what it called its growing appreciation of public needs and of the necessity of finding ground for a rational compromise between individual rights and public welfare. So it adopted a test that allowed states to freely impair contract rights if their laws served a legitimate end in a reasonable way, and it held that the Minnesota law did both. It was a legitimate end to help homeowners in distress, and it was reasonable to temporarily extend the redemption period. So after Blaisdell, it really is, in my view, in many respects, the critical case in which the rest of the decades, the strict scrutiny and rational basis review and all these different policy-laden tests that you read about today have really developed. But there's always been a competing approach, and it's what I will call the history approach. Under this competing approach, the court solves the level of generality problem by looking to our traditions. As the court explained in one such case, any test that it adopts to interpret a clause must acknowledge a practice that was accepted by the framers and has withstood the critical scrutiny of time and political change. That is, the history or novelty of a practice can prove or rebut its constitutionality without judicial inquiry into its policy merits. So how prevalent is the history approach as compared to the policy approach? For those who have a greater lens than from the 1930s and 40s, would suggest that this was the dominant approach. Indeed, the legal realists were trying to make an innovative change. And so if you look before that time, you can see many cases that rely on tradition. I'll just list one. Murray's Leasey is the first time the court interpreted the Due Process Clause, and it relied entirely on tradition. It read the clause to incorporate the settled usages and modes of proceeding existing in the common and statute law of England that the colonists adopted on this side of the Atlantic. So unlike in later cases in Matthews v. Eldridge, the court did not choose the process due using its own views of desired policy. It suggested that the process is due is the process that was always due in a given case. And after Blaisdell, there was, here and there's cases decided totally on history. There's an Establishment Clause case where the court upheld legislative prayer based on the longstanding practice, and a few others. But it's really come in recent years that it's seen a resurgence of the use of history. Indeed, I would predict that it's almost eclipsed the policy approach to judging. And if historians may someday describe the present time as a jurisprudential inflection point, like the time in the 1930s when the legal realist movement really took hold. And this change started with a trickle. The Confrontation Clause was adjusted in Crawford to have a history test. The court adopted a history-focused test in Heller. But it really has, in the last few terms at the court, it really has picked up. The court has overruled Lemon for the Establishment Clause and adopted a history-grounded test. And what I think is even more significant, so as I mentioned earlier, the free speech context is really where the policy approach to judging has reigned supreme. But 2 terms ago, they upheld a trademark law using only history and tradition alone and not inquiring into the policy merits. So what explains the reemergence of history as a guide? So if legal realism was what somebody described it as the most significant jurisprudential movement of the 20th century, I would say originalism is the most important so far, at least has the early lead for the 21st. Justice Barrett recently suggested that originalism was built on 2 core principles: that the meaning of constitutional text is fixed at the time of the ratification, and that the discoverable historical meaning has legal significance today. So the competing approach, originalist approach, really grew out of kind of a view of the excesses of the realist approach to judging. But at the outset, I find it quite interesting that a lot of the early originalists, like Justice Scalia and Robert Bork, they actually agreed with legal realism in part. So they agreed with their legal positivist outlook. Justice Scalia readily accepted the realist critique of the common law. As he explained when bemoaning the emphasis on the common law in education, first-year law school is so exhilarating because it consists of playing common law judge, which in turn consists of playing king, devising out of the brilliance of one's own mind those laws that ought to govern mankind. How exciting. He thus agreed that a common law judge's function was to make law and not to find law, like the traditional views of common law judges. So the originalist critique was really about how they changed this mindset, this idea that judges should engage in policy to codified text, both statutes and the Constitution. And they raised structural, tradition, and workability concerns. So structure, they essentially thought it violated the separation of powers. So when it came to written texts, either the people in the Constitution or the legislature in a statute exercised, quote, the sovereign voice, not the judges. And judicial policymaking undercut the framers' design. Justice Black actually did not like this type of policy-based approach, and he explained when criticizing the court's free speech decisions that the framers themselves did this balancing when they wrote the Constitution, and courts lack the power to make a different evaluation of the importance of the rights they put there. So that was kind of a separation of powers idea. The next idea was just what Justice Thomas has called outside the court's interpretive tradition. So policy kind of laden judging does not have a historical pedigree. You could look at many founding area examples of this. My favorite is Justice Story's view and his commentaries. Their Story noted that arguments drawn from impolicy or inconvenience ought to be of no weight in constitutional interpretation. He thought there was no more unsafe guide in practice, this is now Story's language, than mere policy because of difference of opinion on policy questions. According to Story, the policy of one age may ill suit the wishes or the policy of another, but the Constitution is not to be subject to such fluctuations and is to have a fixed, uniform, permanent construction. So I think it's safe to say from these comments that Justice Story would have dissented in Blaisdell. And then the last is workability concerns, as Justice Kavanaugh recently said, and Rahimi. The policy approach is highly subjective. The court hasn't even answered basic questions about the goals. So the court has suggested that there's a social welfare theory of judging, right? So what is a compelling interest? But it hasn't told us what philosophy we should adopt. Is it the philosophy of Hume or of John Rawls or of John Stuart Mill or Aristotle? Next, a lot of these interests, I said this in an employee speech case, a lot of these interests can't be compared. No better line is Justice Scalia's famous critique of one such balancing test, that it's like evaluating whether a particular line is longer than a particular rock is heavy. So they're incommensurable interests. Yep, so that's the third one. And then no case better emphasizes the switch from policy to history than the court's recent decision in New York State Rifle and Pistol Association versus Bruen. So Bruen was about the Second Amendment. The court had for a long time, or the lower courts at least, had for a long time relied on the policy-based approach to judging, because that has been what the court had been directing courts to do for the last 70 years. And the Supreme Court rejected that approach and said that we should be grounding it in history. The court recognized it has a fixed meaning and that we need to determine the fixed meaning based on reasoning by analogy to historical examples. So applying this approach, the court found that a special needs law for carrying a firearm in public was unconstitutional. I do really think Bruen shows that the court has come full circle since Blaisdell. It has told us that the Constitution has a fixed meaning and that the court should follow the common law method of logical reasoning, the very method that folks like Holmes had criticized as being too indeterminate. So that's a basic divide between the policy approach and the history approach to judging. I now want to transition and just talk about where Hayek would have been on this. And I think the bottom line is that Hayek would have been a tradition-focused originalist, but I think he would have picked that view for different reasons than the reasons that perhaps Justice Scalia and Robert Bork provided. So Hayek just had a fundamentally different view of the nature of law than the legal positivists. He said that the word law could refer to two different types of things: what he described as the rules of just conduct that governed a spontaneous order, or the rules of an organization that governed a humanly designed entity. And he viewed only the rules of just conduct as rules that actually were law. According to Hayek, they preceded government, they did not arise from government. So individuals followed these rules or customs when they came to live together in those orderly relations which we call society. In other words, he thought the word law described the invariable rules that govern nature, like the laws of gravity, and men's conduct, like the laws against murder. So Hayek is very abstract, but he always gives the example of private property. So private property rules would be the rules of just conduct. According to Hayek, historical research refuted any notion that property rules actually were invented by the government and that they preceded the rise of even the most primitive cultures. What's critical for Hayek is that these rules of just conduct are actually not designed by any human's will. They are what he called purpose independent, because a human did not adopt them to achieve any goal. We might not even know, according to Hayek, why they are what they are or their effects on society. And since no human designed the rules, individuals were not forced to follow another person's will when they complied with them. Their generality as well, the generality of the rules of conduct, led legal philosophers like John Locke to say that liberty could not exist without law, and to distinguish these philosophers from others like Hobbes, who thought that all law encroached on freedom. So Hayek would have been in the first of these, that law was necessary for liberty. But what he meant by law was that these rules of just conduct. Now Hayek contrasted the rules of just conduct with law of a different kind, namely the rules of the organization of government. He referred to these rules as the public law and recognized that human will had in fact created them. So the rules of organization were designed to achieve particular ends, unlike the rules of just conduct, namely the ends of running a government. So nobody created the rules of just conduct, according to Hayek, but the way the government enforced those rules was a result of designed structures. So Hayek placed constitutional law in the set of organizational rules, because it existed as a superstructure erected over the rules of just conduct to organize their enforcement. And so Hayek, I think I would give an example of the Contracts Clause again. So the freedom of contract, according to Hayek, would be a rule of just conduct that just kind of developed naturally, not from anybody's will. And the Contracts Clause would be the founders' humanly designed method to enforce this rule of just conduct. So the reason why I say these views are fundamentally different than the realists and the many originalists like Justice Scalia, is that it rejects the legal positivism of the realists and those originalists. So recall the realists ridiculed the notion of an unwilled law as a brooding omnipresence in the sky. And Justice Scalia, in matter of interpretation, as I just said, he was content to say that judges made law in the common law context. Unlike Justice Scalia, Hayek would have disagreed with the legal realists across the board. He did not think that anybody made the rules of just conduct, and nor did those rules rely on somebody's will. He said, only when it is wrongly assumed that all rules of just conduct have deliberately been made by somebody do such sophisms become plausible as that there must always exist an ultimate sovereign source of power from which all law derives. So what can we take away from these rules? Number one, I think Hayek would have fundamentally rejected Airy. He would have agreed with Justice Story that there were a general body of laws that judges can discover. So like Professor Stephen Sachs at Harvard has recently come out and critiqued Airy and suggested that Swift was right. And I think his one sentence from Sachs's article actually articulates Hayek's position well. A system founded on social practice could incorporate rules external to its own society. These incorporated rules would be given sovereign authority without the need of a sovereign author. So I do find it interesting. Does this suggest that Hayek is a natural law person? And the answer is yes and no. He does believe in natural law, but his views of that phrase differ from, say, Adrian Vermeule's or Hadley Ark's. According to Hayek, the Latin word naturalis was a technical term for such social phenomena as were not deliberately shaped by human will. He thus viewed the rules of just conduct as natural in the sense that they weren't developed by anybody. But he criticized the gradual change in the definition of natural law to mean rules that meet the design of natural reason rather than traditional practice. Hayek rejected the rationalist view of natural law, which suggested individuals could intentionally construct rules by deduction from explicit premises about nature. So whose views do Hayek's resemble? I'll give two quick examples. First, as a historical matter, Hayek resembles Edward Coke, who he called the great fountain of Whig principles. According to the legal historian Harold Berman, Coke's historical jurisprudence straddled the line between legal positivism's authority and natural law's reason. When discussing the common law's artificial reason, Coke criticized the notion that any one person, including the king, could outsmart the tradition of the ages, explaining that no man out of his own private reason ought to be wiser than the law, which is the perfection of reason. Hayek has essentially said the same thing. As he said, the results of the experimentation of many generations may embody more experience than any one man possesses, and the rules of just conduct came out of that experimentation. As a modern matter, I think Hayek's views, I've already mentioned Stephen Sachs, I think Hayek's views look like those original scholars such as Will Bode, Judd Campbell, and Stephen Sachs, who have emphasized the general law in constitutional interpretation. They describe the general law as conventionally unwritten law derived from general principles and customs operating across jurisdictions. So Hayek used the word rules of just conduct, but I would just equate that with what these scholars have called the general law. So briefly to sum up, what does this mean for the nature of judging? First, Hayek rejected the fallacy of the logical form. He actually criticized, so the fallacy of the logical form that general principles don't decide concrete cases. Obviously, this would be problematic for Hayek, who thought general rules of just conduct should govern society. So he criticized Justice Holmes' classic phrase, general propositions do not decide concrete cases from Lochner. He suggested that that was just a fundamental attack on the notion of we have a rule of law and not of men. Hayek did agree that there will be close cases and that there might be an indeterminacy of logic alone. But he would have harshly criticized the legal realist response to this indeterminacy. So as I explained earlier, the legal realist's response was to look to policy and social welfare. Hayek could not disagree more with that approach. First, I think, as I said, I think he took a more formalist view of a judge's office than most originalists because he thought even in common law cases, the judge's where common law was something to be discovered, not made, and the judges were formulating the rules, and judges formulating the common law rules do no more and have no power to do more than to find and express already existing rules. So he praised Cicero, saying that the conception of the judge ought to be merely the mouth through whom the law speaks, and he actually traced the saying from Coke to Chief Justice Marshall, who explained that courts are the mere instruments of the law and can will nothing. And second, and even more fundamentally than Justice Hayek's formalism, would have been his rejection of any utilitarian notions of the public good and judging. Although he did not mention Cardozo by name, Hayek's writings contain direct rebuttals of Cardozo's reasoning. So Cardozo is known in his book, The Nature of the Legal Process, for a famous maxim that the welfare of the people is the highest law. Hayek actually took the Latin of this, salus populae supremi lex esto, and he said this maximum, the welfare of the people ought to be the highest law, just meant that the general rules should serve social welfare. It did not mean that judges should carve out exceptions to those rules whenever they thought a particular social end called for it on a case-by-case basis. And so, Cardozo also mentioned the method of sociology. As I mentioned, he had a history tradition in sociology. Hayek expressly criticized what he calls an alliance of law with sociology. He did not believe that judges should decide cases by estimating the specific effects of particular measures on society. According to Hayek, judges should never ask whether the action taken in fact was expedient from some higher point of view or served a particular result desired by the government. Likewise, a judge cannot be concerned with the needs of particular persons or groups, or with the reasons of state or the will of government, or with any particular purposes which an order of actions may be expected to serve. Rather, Hayek thought that judges should enforce the rules of just conduct even when their known consequences in a case are wholly undesirable. In other words, he said, fiat justitia pereat mundus, let justice prevail even if the world perish. So why did Hayek take this harsh approach to judging, judges being formalist and not worrying about consequences? Number one, like some of the originalist scholars, he thought the approach was subjective. He explained that the common welfare or the public good has to the present time remained a concept most recalcitrant to any precise definition, and they're therefore capable of being given almost any content suggested by the interests of the ruling group. He also relied on a lot of his economic work. He didn't think judges had the capabilities to do this. So Hayek got his Nobel Prize work based on his broader economic thinking that central planners in socialist countries could never obtain the large amount of data necessary to efficiently allocate society's resources to their most productive uses, but that the price system in a capitalist country can amalgamate this data. Hayek thought the same thing for utilitarian judges. He says most of the effects on particular persons of adopting one set of rules rather than another are not predictable because of our lack of knowledge. So despite kind of what Judge Posner would say about a judge's purpose, Hayek would have said that that is just something that is doomed to fail because judges don't have all of the information, nor could they ever get all the information necessary to determine what would move the needle on social welfare. So in short, Hayek thought that a judge acted like, he basically said this, a judge acted like a socialist if the judge engaged in a, quote, balancing of the particular interest affected in the light of their importance, and he viewed socialism as irreconcilable with impartial judging. So I think we can safely predict he would have rejected Roscoe Pound's call for social engineering judges. So briefly, what this means for the Constitution. Well, one quick thing, I did find it interesting that Judge Posner actually basically agrees with this. He said the only thing, he interpreted Hayek to say that the only thing a judge should do is enforce custom without regard to consequences and extinguished any role for economic or other social scientific analysis and adjudication. Judge Posner found it ironic that economist Hayek, quote, economist Hayek, closed the space that economic analysis might occupy in adjudication. But I don't think, as I said, based on what economist Hayek said, this should be surprising. As Todd Zwicky and Anthony Standers have noted, The challenge of economic planning under socialism is readily applicable to the challenge of a wealth maximizing Posnerian judge. So this, I think, would have consequences for what we think of as the modern test today in many areas in constitutional interpretation. All of this test, strict scrutiny, rational basis review, require folks to balance, on the one hand, a right, and on the other hand, a government interest. And I think the importance of the particular objective of the government should not affect judicial decisions under Hayek's approach. So how would Hayek have viewed Blaisdell, the Contracts Clause case? I think he would have descended from the bitch in Blaisdell. Indeed, he criticized it in Law, Liberty, and Legislation and other decisions of the U.S. Supreme Court during the earlier period of the New Deal because he says this, they conceded to the legislature unlimited powers to safeguard the vital interests of the people, saying in effect that for any end a legislature regarded as beneficial, it might pass any law it liked. So these decisions, according to Hayek, gave states the power to run roughshod over the constitutionally rooted general rules of just conduct whenever they found it expedient. Now, in this case, it would be the freedom of contract. The decisions thus undercut what Hayek believed to be the purpose of a written constitution, to prevent the legislature from infringing certain general principles for the sake of temporary and immediate aims. They also undercut what Hayek saw as the primary role of a judge to enforce the legitimate expectations that parties had formed based on the rules of just conduct. So as compared to that, I'll just briefly mention substantive due process. Hayek also criticized the Supreme Court's substantive due process cases. But I think he did so, he criticized them as being not textually rooted. But I think this was a soft criticism. He did point out that the due process seemed like a procedural rule, but he also seemed content with the Slaughterhouse decision, or not content with the Slaughterhouse decision, which he said rendered the Privileges or Immunities Clause a practical nullity. So he might have been willing to read the Privileges or Immunities Clause to have some of the same types of substantive rights that were being enforced in the Lochner era. At the same time, I think he objected to the Lochner court's method of reasoning. So it was more reasoning rather than textual support for why he disliked the Lochner court. The court did not ask the types of questions he thought proper for judges, including whether legislation infringed general principles, these are his words now, written or unwritten, which the Constitution had been intended to uphold. I think he was perfectly content for judges to decide based on tradition that there were unwritten rights. But that's not what he thought the court was doing at this time. The court was asking whether the purposes for which the legislative powers were exercised were reasonable on a case-by-case basis. So in many respects, this reasoning foreshadowed the realist policy approach, and Hayek suggested that the court was clearly overstepping its proper judicial functions and arrogating what amounted to legislative powers because it was engaged, again, in this type of balancing that he thought had no place for judging. So what would Hayek have done in Bruen, the other case I mentioned? I'm pretty confident he would have liked that one. So as a general matter, Bruen recognized that the Second Amendment enforced a pre-existing yet unwritten right. This would have been essentially Hayek's rule of just conduct. He would have said that the Second Amendment codified a rule of just conduct developed over many years, an individual's right to keep and bear arms for self-defense. As he put it, even constitutions are based on or presuppose an underlying agreement on more fundamental principles, principles which may never have been explicitly expressed, yet which may make possible and precede the consent in the written fundamental laws. And as a specific matter, I think Bruen's reasoning by analogy approach would be also Hayek-type judging. And I say that because he essentially thought that judges should engage in this type of common law reasoning. Rather than ask about any wishes of a ruler or any reasons of state, Hayekian judges will have to find some, what he quote said, some yet unarticulated rule which serves the same function as the unquestionably accepted rules of conduct. That is, Hayek said that a judicial decision must be logically deduced from recognized rules, or at least consistent with the existing body of such rules, in the sense that it serves the same order of actions as these rules. So I tend to think that Hayek would have accepted the common law method of developing rights through logic by analogy and adopted it for the Constitution. As I was telling Professor McConnell before we came in here, I would view him closest to what I consider, as I said, Professor Sachs, Bode, and Judge Campbell. Those professors have written lots of articles on how the Constitution codifies the general law, what they call it, the unwritten law, the First Amendment, the Second Amendment, the 14th Amendment, others, the Fourth Amendment. And I think Hayek would have thought that these rights expressed fundamental customs or background rules of society, and he would have been content. So he wasn't really a textualist, but I would strongly think he was an originalist and would have been content to enforce unwritten rules as long as they did so through the method that he thought was appropriate, which was trying to deduce tradition through common law analogy. So yeah, that's all I've got. So I'm happy to take questions. I'm happy to do whatever. Yeah.
Well, I disagree. One of the great difficulties about Hayek is he doesn't have a systematic mode of interpretation. If you start going back to the classical sources, particularly the Roman sources and then the early English sources, they start with a method of prima facie case, exceptions, and so forth. And it turns out there are two elements in that theory which you sort of have to take into account. One was the principle of necessity as being the dominant rule for explaining when property rights as commonly conceived have to be overridden. And the second set of rules that he started to say was that this was a kind of a pleading system in which what you had to do is to figure out how you take the various sequences and put them together. So the problem that he had on this, which is everyone has, he was a person who tended to think of liberal rules deciding cases in which you already know what the outcome is in terms you did or did not take that. The problem with that approach is to everybody is suppose you have a rule which is designed to regulate future conduct, and what you're worried about is whether it's going to be too broad or too narrow. And so trying to deal with errors under circumstances of uncertainty, the question and the challenge to you and to Hayek was how do you do that without having some kind of a balancing test to figure out whether one kind of error is too big or another. So you have to have a highway rule. You set the speed limit at 1 mile per hour or at 100 miles an hour, and you start to reject both of them. So where do you put it in the middle? And then where do you allow exceptions to? So the question is, I don't think he's very good, and I think the same thing is true of the Sachs and Campbell stuff. They're not very good at handling the way in which you do prospective laws, which in fact have to deal with future uncertain situations where I think it's extremely difficult to avoid some kind of a balancing test constrained by the legitimate ends on both sides.
What do you think the balancing test should be, though? So he would say you should develop essentially what the court did in Bruen and Rahimi. You can question whether the level of generality picked in Rahimi was appropriate, but I think his strongest pushback would be that government policies should affect what he considered to be rules of, or intrude on rules of just conduct. So that's why he was so opposed to Blaisdell. So it would be a freedom of contract rule. He was content with exceptions, so he thought that he was content with the usury laws or limits. He didn't think that those violated, but he was concerned with giving the legislature the power to come in and retroactively change contracts kind of on a case-by-case basis.
And that's where the just compensation principle came in. Because if you look at this in the light of bankruptcy law, you say, well, you can certainly postpone this, but you have to give protection to the guy who cannot collect on his security interest. And that's the way in which these things tend to go in bankruptcy.
Yeah, no, so he would have been...
and so the issue is, he was very weak on talking about the just compensation principle. in his argument, then I think a lot of the cases you're talking about can be resolved by thinking a bit harder about that.
Well, I think he would have been content with, in Blaisdell, he would have been content with giving relief.
Yeah,
But he didn't think they should do it through blowing up a contract.
Yeah, I'm not disagreeing,
Societal,
but the intermediate position, which is the bankruptcy solution, is he doesn't talk about what the right solution is. Because, I mean, there's a banking crisis, the deflation and so forth. And if you did not, under these circumstances, have some kind of intervention, the entire banking system would have fallen apart, because it turns out if the farmers can't repay their loans, then the banks cannot repay their depositors on an at-will contract, and you have the bank crisis, which is what happened, of course, in that particular case right after Roosevelt took over. So, I mean, that's what I think is one of the points. But somebody else should ask a really important question. Somebody? Oh, Jonah?
I can hear you.
So I think a lot about sort of like convergent evidence and why, as an originalist and a contextualist, it's less troublesome to use history than to use policy. And I think it is because policy shifts forever. How vulnerable, as a practical matter, and as a judge, are you worried that people will sort of start to turn history into some malleable objects, sort of embrace different rogue accounts of history as they can with policy, in order to sort of create some convergent alignment between their view of history and their view of the text?
So you want my view or Hayek's view? So my view would be, it has to be good history, and it has to be. I suppose one critique of Bruen is Justice Thomas dropped a footnote and suggested it was the history developed by the parties. That may be the case in the Supreme Court and the Circuit Court. I think that oftentimes parties do enough to preserve questions, and I think it's the onus has to be on us to try to do our own research. I don't think parties can, for instance, waive case citation, or forfeit would be the proper term, forfeit case citations. And so it seems strange to me to think that they could, as long as they're advocating for the legal conclusion that they are, I would think all methods of interpretation in support of that conclusion, the judge has an independent duty. So yeah, I mean, the problem with history is it's a legal realist critique that I think needs to get worked out. So the legal realists were like the general rules were indeterminate, and then that you're really relying on something else. I often compare Rahimi, which is the case that said you can disarm dangerous people, to Alvarez, which is this case that struck down the Stolen Valor Act. And if you look at the level of generality that they picked in terms of determining the historical rule and how you turn that historical evidence into a kind of a rule to guide litigation, they picked a sky-high level in Rahimi, right? Based on these like surety laws and going armed laws, we adopted general rule. That's like a high level, a general rule that you can disarm people. In the Alvarez case, defamation, fraud, all sorts of traditional rules against false statements have existed for time immemorial, but the court picked a very low level of generality on which to describe what is protected, almost closer to it has to be analogous to those things. And the court didn't really do a good job of kind of differentiating it. So that it seems to me the hardest when you transition from, okay, we've accepted history and we're not doing policy, the level of generality problems are not going to go away. And I think that maybe the court could be critiqued on needing to do a better job of articulating the rules. I just actually emailed Will Bode a couple days ago saying that he really needs to come out with a new, like, old school common law. Like, how did common law judges decide these cases? Because it's like reasoning by analogy and coming up with, like, how do you turn a kind of a historical example into a binding rule that should govern today.
Who's at the end?
Hi.
Oh, hi.
Should I grab the mic?
Yeah, sure.
And then,
I have a question as well, but
Oh, sorry. Yeah. Thank you, Judge Murphy, for coming here. My name is Rita. I'm also in Professor Rosenblum's American Legal Thought class, so I thought that this was a great review for my final exam. I had a question about the dichotomy you posed between historical tests and policy tests. So you kind of tied policy tests to the legal realists. And my understanding of the legal realists is that they're really concerned with the effects that the law has and certain decisions that the law does. But I guess I'm confused at what a historical test is supposed to do that's different from a policy test, in that I feel like, isn't a historical test just caring about what the law does, but in the past rather than like in the future? So I guess, yeah.
I would. The key distinction, it seems to me, is it's objective versus normative. I am like, even as today as a judge, it's really difficult. Like, is this policy good enough? And it's like the judge. It doesn't seem like the role of a judge to me. Objective inquiry about the freedom of speech is a vague term, but at the time of the founding, we know it excluded perjury. So it seems quite unreasonable to think that whatever this term means, especially with the definite article thought, it was talking about something pre-existing, as Hayek would say, it's one of the rules of just conduct. We can figure out what they thought was the scope of the rule of just conduct by looking at it from just, okay, what things were allowed at the time. And so it's not me acting as what I consider to be a legislature, which is, I suppose it's the structural point, the separation of powers and what is the traditional office of a judge. Philip Hamburger has this great book on law and judicial duty where he goes through the historical office of a judge. And it is to neutrally interpret the law, not to be a policymaker. And when you're actually asking, is this law good enough? You're not in, what are you interpreting? You're just making a decision. I mean, why in the Handbill case that I mentioned from 1939, why is restricting handbills on the public streets more or not as important because of litter concerns as allowing people to, hand out these handbills? Why? It's like, as a judge, that does not strike me as necessarily a question suited for judging.
Mario?
Thank you. I have a question about the historical approach. Given that you said the 20th century was dominated by legal realism, what does historical approach do about the 20th century? I mean, if you're going to use historical arguments, then you have to skip the 20th century and go back.
No, there's certainly stare decisis concerns, I would think.
Yeah.
I mean, you could make the argument that what did the 1930s do that what pre-existed it? But so yeah, I think Hayek would say there is something to stability, but the court has been doing is just it's funny. It is kind of gradually evolving. So in some areas they have overruled, right? So the Lemon test has now been overruled by what I consider to be a more historically rooted test, and so the court has just jettisoned that as unworkable. But in other contexts, I see gradual changes. So I could see some of these tests being turned into historical tests. So strict scrutiny, is there a compelling interest? Well, is there a long established practice of the government doing this? And so maybe you are answering these tests that were created in the policy-laden era using historical evidence. It'll gradually transform in that fashion.
Just as a funny story, I have a friend who used to say that the 20th century was a mistake. And it might apply here.
Hi. If I understood you correctly, I think you indicated that Hayek had a justice policy as a fundamental, but he had some inconsistent views about how you maybe determine what that policy is. If you start from the principle that individual liberty is the fundamental policy, it would seem to me that any decision designed to move the needle away from individual liberty and towards an expanded government power, and some justification is introduced for that purpose, that the judge introducing that purpose is essentially lying in order to justify what he'd like to have instead of what is. Have I come close to at least what the implication of justice would be for Hayek?
Well, I think Hayek would. Hayek had interesting views on what, for justice, he said you have to have a willed end.
You have to have
a willed end. So, like, he didn't think the rules of just conduct were just or unjust. He thought they just existed. He suggested justice is always tied to intentional action. So I do, like, he thought the rules of just conduct were useful. It's just that this is the debate between whether law creates liberty or law always intrudes on liberty. He would agree with you that traditional law, what he viewed as law, creates liberty. It's almost like the million harm principle. It gives you your own sphere in which you can perform your own actions for your own purposes, independent of anybody else. And that's the function of these customs, freedom of contract and property rights. I don't know that, I mean, I think he would have said that it has led to a great amount of human flourishing, and so we shouldn't be willy-nilly messing with it. But I don't know that he would say, I mean, I suppose he would call it justice, but he was very careful. Like he said, like we're talking about just prices. So oftentimes you hear, like, what is a just price for something? He would say that that's kind of nonsense, and that the free market lands on a price, and it's not just or unjust because it just exists as a natural.
Yeah, but that's going into different words, different meanings of words used for different purposes.
Uh-huh.
Yes.
Thanks a lot for the talk, and I agreed with a great deal of it. But one aspect puzzles me, which is your association of positivism with. I believe you thought that Scalia maybe made a mistake because he understands himself to be a positivist. You say this is accepting one of the tenets of legal realism, and that Hayek has a better approach because Hayek doesn't think that the most important principles have any determinate origin, and applies a traditionalist approach to sort of figuring out those principles are. But as applied to the Constitution, this strikes me as rather puzzling because unlike the common law, we actually have a text, which is the Constitution, and it begins by telling us that we, the people, do ordain and establish this Constitution, which makes it sound as though there's a sovereign out there, namely the people, and that they ordained and established a law for the future governance of the country, and that the reason why the Constitution is authoritative is not ultimately because it is good or bad, or even to the extent to which it conforms to rules of just conduct, but rather the people have a right to establish for their own governance the rules that seem to them to be most constant, which is what the Declaration of Independence says as well. What they think is most consonant with good government, and if that's so, it seems to me the principles of originalism follow from a positivist conception of the Constitution rather than from the opposite. Because if you think that the Constitution has authority not because it was ordained and established by the sovereign, namely the people, but rather because it conforms to just principles, we then have to argue about what the just principles are. And I think that opens the door to things like legal realism, where judges are just as capable as anyone else of reasoning about what just principles are and using them instead of the principles which were intentionally embodied by the sovereign when they ordained and established a constitution.
Yes, so I would agree with much of that. I think originalism can be grounded in either legal positivism or Hayek's views. I do think that Hayek has some, and if I had read more, he has some statements that are quite would make a textualist, or would make you wonder whether he was a textualist. He really thought that the Constitution's words, expressed in words, ideas, or established customs that society followed before words. So he would have been content to, I think maybe more so than you, to enforce implied rights is my best guess. And whether that's good or bad, I suppose, depends on a lot of factors. I would say he would not have been content with the legal realist approach to enforcing implied rights. I think he would have required something much closer to Washington v. Glucksberg. So it would be tied to tradition and not to objective weighing about what is a just society. Because I do think he was also very critical of natural law lawyers. So he would not have been a fan of natural law judges who think that they can reason through to the appropriate problem. I think he just thought you should enforce custom. The best evidence of custom is the text, but it might have some gaps that you need to fill. And that's actually, so I can give you the quotes afterwards. That was his view. Whether that's right or wrong.
Yes. So on the answer that you just gave, if I understood the lecture correctly, it sounds like a big assumption inherent in this theory is that the rules that we write down in a constitution are supposed to be like the written embodiment of the people of what are preceding rules of just conduct. But that seems to me to be a big assumption, because obviously you can envision a constitutional amendment that goes against the rules of just conduct. And certainly there are constitutions in other countries around the world
His other book, Road to Serfdom.
Okay. So where in our system, what is the role of a Hayekian judge when evaluating a challenge to a constitutional principle, a constitutional rule where the text clearly is against the rules of just conduct?
So I could, so this is why I say he's not a textualist. He says, Hayek suggested that judicial decisions have most often shocked public opinion when they struck to the letter of the written law and dared not depart from the result of the syllogism in which only explicit statements of that law could serve as premises. So, I think Hayek would have been perhaps comfortable with Holy Trinity in a way that, that was Justice Scalia's famous, like the evilest case out there was the using purposes to trump. It was a statutory case involving whether a minister could be brought in to the United States, and the text seemed to ban all employment. I forget the words of the text, but the court actually said we are a religious people, so we're going to read in an implied exception for ministers. And this was like, well, this is totally antithetical. A rule of law is what the words should have binding effect. The words should plainly cover. I think Hayek would have been comfortable with strong canons of interpretation. So he would have been comfortable with the rule of lenity, so in these other substantive canons, and he would have been like the major questions canon. The court is kind of doing this today, right? There's some general capacious language, and the court is saying, well, we're not going to read the language as broadly as it could possibly be taken. And there's debates going on right now about what's the basis for this. So Justice Barrett would say, well, it's a kind of a contextual point. But Justice Gorsuch would be coming out with this vigorous non-delegation type canon. And I think he would have been more inclined to think that you can, if it's capacious text, use these types of substantive background canons that are tied to the rules of just conduct to read the text narrowly. Whether rightly, wrongly, I mean, I'm just, this is kind of my views. I do think Hayek is an originalist. I just think he would be, as I said, an originalist who's comfortable enforcing unwritten norms as glosses on the text. Dan? Yeah.
So I'm glad you brought up canons of construction here, because I think that's a real challenge. I was going to ask first how you view something like rational basis review, right? It seems like you're painting a very broad brush as to what is a policy-driven decision, but just saying whether there's a rational basis for a law doesn't necessarily say whether something is a sufficient compelling interest or is compelling enough. And then on the next spectrum, you could say, well, canons of construction seem like they're rules that judges make up as to how to approach text, which is almost policy driven. It's not necessarily about how should society live, but it's what's the best way for us to engage in this act of judging, right? And interpreting the Constitution. And then you might even say that the idea of a compelling state interest or strict scrutiny, that's kind of almost like a canon of construction. It's judges saying, well, we really need to look at something very closely if it implicates certain interests. I'm not saying I want society to be this way, but that might be a rule that judges adopt for dealing with certain concepts, not simply broad brush legal, Posnerian, what creates the most economic welfare or what's the best society, but they do seem to be ways of judging or methods of judging that are something short of what you're most concerned about.
Yeah, so I think that was more me than him. So I was describing a policy-laden test as any test that requires the judge to evaluate what I view as whether it's a good idea. And I would put rational basis in that camp. And I do think that you are right in terms of distinguishing rational basis review from strict scrutiny and where do you do so. You might say that is based on some type of historical inquiry that we think that this is the core of the right. But the ultimate determination, in my view, is still policy-laden in a way. I suppose the rule of lenity, you could arguably say, is policy-laden because it's promoting liberty, right? So it's in ambiguous cases, the criminal defendant goes free. But I do think that it's enforcing a pre-existing norm that dates back. Chief Justice Marshall called the rule of lenity old. So we know it dates back a ways. And I do view those as tied to something that's, at the end of the day, the rule of lenity gives an outcome, right? So it's like the defendant goes free. It doesn't say, judge, go assess the merits of this law. And I just any test that requires judges to engage in this policy making, at least I don't think Hayek would have been in favor of for all the quotes I said about judges should not be concerned with the affairs of government and the rules of the legislature, why they exist. Yeah. Good.
Okay, good.
Just two questions with two answers.
Oh, go ahead.
What would Hayek think about the distinction between elected judges and appointed judges? And then what do you think? And what would Hayek think about outsourcing judicial decisions to these large language models, which might be less likely to make cognitive errors that humans make? What do you think?
Okay, so the first elected, I'm trying to think of where Hayek would be on. I do not think he would have been a fan of elected judges. No, this is just me coming from memory. He did like life protections. It seemed he thought that was a stable improvement for neutral judging. He also he has a chapter in Law, Legislation, and Liberty on his model constitution. And he had idiosyncratic ideas on what the model constitution. He thought there should be a separate legislature whose sole job was to deal with the rules of just conduct, and another legislature whose job was to deal with the rules of organizing the government. But he also thought, I think he thought that the judges in that constitution should be not elected either, but I could be mistaken. But my instinct would be he would have been in favor. I like a life appointment. I don't know. I have strong views. My state colleagues would say they're kind of more representative of the people. But is that a good or a vice if you think that a judge's job is to sometimes the rule of law may lead to unpopular decisions. And so that could make you less willing to do that if you think you're going to lose the next election. And what was your second one? The canon. Yeah. I think he does think that judges. He does not think that judges should be engaged in policy making. So in terms of what do the words mean, I mean, my instinct is he would not be in favor of that, but it goes back to he just isn't a strong textualist. So it wouldn't really. I don't know that it would matter to him all that often. I think he thinks that he's perfectly content, whether rightly or wrongly, if the rule seems to be written in a way that trounces a well-established background norm, that judges should do their best to see that the background norm is respected. And so I don't think those models that you're talking about would do that. From my perspective, I actually find it. I haven't used them yet in opinions. I have I'm just a novice. I need to go to some, but looking up Westlaw, you can do this just by. There's so many other sophisticated ways to do this, but you can do it just like the media in Westlaw, the news articles in Westlaw, or other things. I do have a concern that we would be putting what Scalia said on laws, garbage in, garbage out. You have to really respect the model, because it's really dependent on the scope of the database and whether you think it's reliable. Maybe kind of like the legislative history point too, that you have to take it with a grain of salt, I suppose. But yeah, no, I think it's a good idea. Good, I agree with you on the intuition point, that it seems strange. It's almost like in trademark cases, you ask, you could run these studies. Does this trademark have secondary meaning? And you go and you talk to ordinary people. You could almost see that being done in statutory interpretation. What does this word mean? You could just pull a whole bunch of people. Instead, we've historically just relied on judicial intuition, which I guess I suppose I share your instinct on the concerns with, is my intuition correct?
Right.
So one characteristic of liberal polities and capitalist economies is they come with a lot of dynamism and heterogeneity over time. And so that leads to legal incompleteness. How does a historic test fare with cases that don't have precedents, that are entirely novel to a legal regime?
So that would be what he said the hardest cases are. And he did talk about new cases, and it's basically what Rahimi did. He said that you should argue by analogy and try to, judges kind of intuitively go to the rule that makes the whole system work, is what would be his conclusion. It may not be all that. I mean, the legal realists obviously did not find this satisfying because they thought they were just hiding the policy preference conclusion. But that would have been his take, is that you should strive to. Professor McConnell talked about in this article in '98 that judges look within the law, not outside the law, and they kind of intuit what is the right result from all of the pre-existing law in novel situations.
We have any other questions? Oh, absolutely.
Yeah, it's been a minute. Thank you so much. Finally, Richard, really appreciate it. So, really quickly, this talk, I'm still unpacking what it means, and I'll get to the bottom of it once I get the transcript. So, I've heard a lot about exceptions to social rules, the needs of particular persons, the interaction of black letter law, history and policy, et cetera, et cetera, et cetera. And so in asking this question, what I'd like to do is to draw a parallel between constitutionality and equity. Because as we all understand, with the equitable maxims in the Court of Chancery, there were certain like Latin maxims that were used as a training ground for the bar exam. It seems to me that there may be certain universal truths or possibilities that have actually shaped the development of not only common law, but also statutory frameworks and potentially even constitutions. And so in this vein, what I'm asking is, to clarify, do you think there is a certain normative core or universality that lies at the bedrock of all law, or not?
I do think Hayek would. So this goes to what he thought the rule of law actually was. And most important for him is that all of these rules of just conduct were general. So he would not view it as a good rule to give government discretion to have exceptions on a case-by-case basis. So all the general rules of property law, the general rules of freedom of contract are what give. So his view is that these things developed not through anybody's design, but they served the useful purpose of giving everybody their individual spheres in which they could go do whatever they want and succeed or fail. And that through this process, it allowed for us human betterment. But the critical insight, I think, is that the generality of the rule gives them freedom in their internal space. And so I suppose that would maybe be, I hope that's responsive to your question. Thank you.
We have one last question, Pedro, and then we have the statute of limitations problem.
At the moment of the talk, you mentioned like Hayek's positioning between policy of doing history. And one of the arguments that to justify that, to rationalize that, was that from the position of a judge, it's really complicated for them to absorb the needed knowledge, no? So the epistemic capability problem that Hayek posits in a general sense. But then he would pose that same dilemma to the legislative body, no? Because part of that debate between should the court do policy of history is that who should be doing the policies, not the courts, it's the legislative body. So it's like if I'm going to apply Hayek, I would apply Hayek in both edges, no? Like both for the courts doing policy and both for the legislative body doing policy. I can see how your argument goes forward because, of course, the judge individually, they will have a lower epistemic capabilities than the body. And if there is a sovereign who is the people, it's going to be the legislative body doing so. But then I do not know if I would square out his application to that dilemma necessarily about the epistemic capabilities of the judge and more on what we expect, like the that you expect something from the role of the judge being more easy to calculate in the future, no? Like because it's more less volatile than would be the legislative body. So I was just curious about that. How you kind of see?
Yeah. So this is interesting. So he doesn't think the Constitution itself is a rule of just conduct. So the fact that judges have their rules, traditionally, like his ideal was English common law. And so it developed in England, it developed through the common law method. And so he thought judges should enforce these customs. He says the British Parliament just issued the other type of laws running. But I think that he would be fine. He doesn't so much care about the enforcement mechanism, but he does think that when the legislatures get involved in the rules of just conduct, I would think that he would say that they should be doing the same type of thing. They should be, but it wouldn't be a judicial decision. It would be a law. Well, like a legislatively passed law. But they should not. He doesn't care so much about what they do in the rules of organizing government. But when they start mucking with the rules of just conduct, he would think that the inquiry should essentially be the same. That you should be doing your best to enforce custom. Because the Constitution gives the judges this job. But I think he would be fine with the legislature having the job as long as they are doing the same thing.